okay, let's proceed.
Yes, Your Honor. We filed a motion to overrule defendants' objections to the Chapter 74 expert report. On July 14th, 2023, defendants filed one motion objecting to plaintiff's expert report. We then filed this motion to overrule defendant's motion and have this hearing to allow this case to continue and be prosecuted. So we sued the entities Baylor Scott and White, along with the doctors Danny Little and Dr. Ashley Stoncifer, alleging claims of medical malpractice for their improper care and treatment of a minor plaintiff, ES, which ultimately resulted in life-threatening consequences. Your Honor, just by way of background, the minor plaintiff went to Baylor Scott and White for a planned procedure. Upon completion of that procedure, the minor spent some time in the hospital crying out in pain. He was supposed to get discharged. He then was not. He stayed overnight. Over the course of the night, the doctors, nurses, excuse me, and the staff failed to order a previously recommended CT scan of his abdomen, therefore resulting in a delayed diagnosis of a sigmoid volvulus. So this resulted in the plaintiff having to have an additional emergent surgery, along with the creation of a colostomy that he still has today. So plaintiffs objected. Plaintiffs timely served their expert report on defendants. Defendants filed their objections timely. In their objections, defendants argue that the expert, in this case, Dr. Asit Vora, is not qualified to render opinions because he's a pediatric hospitalist and not a surgeon. Okay. The surgeon initially performs the procedure as an outpatient procedure, and then the patient remains at the hospital for the course of over 19 hours, in which he's under the care of the staff of the hospital, the doctors, residents, etc. Their second point that they're arguing, defendants are arguing that the expert report is conclusory and fails to provide the required elements of the standard of care, breach, and causation. Your Honor, we've attached as Exhibit A the expert report for your review, along with the resume of the doctor. To their first point, they're saying that Dr. Asit Vora is not qualified because he's a pediatric hospitalist and not a surgeon. Dr. Vora, if you see in his resume and in his expert report, he holds over 20 years of relevant experience and is competent in evaluating these particular standards of care for physicians like Dr. Danny Little and Dr. Ashley Stoncifer, the same doctors that managed the post-operative care for the plaintiff, the minor plaintiff. As a pediatric hospitalist, he also has the experience and qualifications to oversee and manage the staff of Baylor Scott and White. He has the training, the expertise. Oftentimes, he is consulted by surgeons like Danny Little when determining how to take care of a patient's post-operative care. So he's highly involved in those situations, very similar to that of this plaintiff. Excuse me. He's a licensed medical doctor, just like Dr. Little, Dr. Stoncifer. And in his position as a pediatric hospitalist, not only is he responsible for caring for all of the pediatricians in the hospital, like I mentioned, he is often consulted by surgeons. He is often managing and overseeing the doctors who are managing the specific care of the patients at that time.
Did you have anything else?
Yes, Your Honor.
Did you have anything else?
I wanted to address the second point, but if you have any questions on that first one,
No, Ms. Owen, what's your response?
On qualifications, my response is that Dr. Little and Dr. Stoncifer are both surgeons. Different specialties will follow patients throughout their hospital stays. It'll include 5, 6, 7 physicians, depending on how complicated a case is. And on a post-surgical patient, there is always at least a surgeon and a hospitalist, and usually other physicians following as well. And that's because they follow an interdisciplinary approach. And the purpose is to see things through each physician's specific lens of their specialized and unique training and experience in their very different disciplines. So Dr. Vora has absolutely demonstrated that he is qualified to speak to what a hospitalist looking through his own lens as a hospitalist should recognize on a post-surgical patient, but he hasn't listed any experience as a surgeon, performing surgeries, being a surgeon, following up on his own post-surgical patients. So a hospitalist like Dr. Vora and a surgeon or a surgical resident like Dr. Little and Dr. Stone-Cipher, respectively, would be looking at this patient through completely different lenses that Dr. Vora simply can't speak to. I think a really good analogy to this is from an outside perspective to a layman. Attorneys would maybe all do the same thing. And I might sometimes, like a physician, if I have a med mal case that has a really complicated probate heirship aspect to it, I might consult a probate attorney to look at that issue. That doesn't make the probate attorney an expert on the med mal issues in the case. And that doesn't make me in any way an expert on the probate issues. So it's the same thing here. And Dr. Vora simply isn't qualified to speak to the surgical aspects of this case.
Response?
Yes, Your Honor. The argument that Emily Owen is making is one for summary judgment or one for trial. At that point, the expert report is only a minimum threshold that puts the defendants on notice as to what is being alleged by the plaintiffs, which the expert report does. The expert report does not require us to put on our entire case, hire all of the experts that we're going to present.
I'll overrule that objection, but I will say that just my knee-jerk response to this is that if you're going to be criticizing the surgery at trial, you're going to need a surgeon to do that. That's not a ruling, but I want to be as transparent as possible that I think that that's if the issue is the surgery, how the surgery was completed, I think you're going to need a surgeon to question at a trial. All right, what's the next issue?
The next issue is defendants are arguing that the expert report is conclusory and that it fails to provide the required elements of the standard of care, breach, and causation.
I read all of that. I think it's fine. It's overruled.
Thank you, Your Honor.
Your Honor, may I respond briefly on the causation issue?
Sure, if you'd like to.
So the issue with causation is more so that there are analytical gaps within it where the chain is not completed by Dr. Vora. So Dr. Vora has to show that more likely than not, doing what he said would have changed the outcome. And all of the standard of care issues point to, if the standard of care had been followed, then this abdominal CT would have been performed at 22:14 or 10:14 p.m. And that would have changed the outcome. But the issue is he then later goes on to say that the twisting happened of the sigmoid volvulus happened. It's a twisting of the intestines in the 8 to 10 hours prior to the surgery. He says on page 16 of his report. Well, this patient was taken to the OR at 10:40 a.m. the morning after Dr. Vora says the CT should have been performed. So per Dr. Vora, that complication happened between the night before at 10:40 p.m. and 12:40 a.m. that night morning. So a CT at 10:14 p.m., like he says it should have happened at that time, wouldn't have shown this complication because it simply wouldn't have occurred yet. So by his own timeline, following the standard of care wouldn't have changed the outcome. And so that's the causation issue here in this report.
All right. Well, thank you so much for your argument, both sides. I'm going to grant plaintiff's motion. And are you guys set for trial already? Let me see.
Yes, Your Honor, we are.
Okay. And do you have a mediator set up?
We have one agreed to, Your Honor.
And who's that?
He was in the order.
I think Dan Marley, but I could be wrong on that.
Let me look.
And sounds familiar.
Your mediator is Ken Rubenstein. Let me just tell you my rule on Dan Marley, because the success rate is so low with him. And my experience has been is that I don't court appoint him ever. If you want to use him, that's fine. But you're going to have to go to somebody I court appoint. So There's a lot of other great mediators out there you can use, but just my experience with Mr. Marley is that Ms. Gonzalez, have you used him before?
We've used him once in a case.
Okay. I'm just saying he just has not had a great track record in my court. And so I would, you're required to go to Ken Rubenstein if it doesn't settle.
Okay. Thank
Understood.
you, Your Honor.
All right. Anything else, guys?
No.
Nothing from us, Your Honor.
All right. You have a great rest of your day.
Thank you. You too. It's good to see you.
Good to see you.
Hello?
All right. Masagi versus Stafford. This does not need to be on the record. It's just well, I guess it does need to be on the record. Are both sides here on Masagi versus Stafford?
Yes, Your Honor. Paul Stafford for Stafford. Good
Your
morning.
Honor, Lance Kasab on behalf of the plaintiff.
All right, let's go on the record on DC 23-14641, Masagi versus Stafford. And we have a substitute court reporter. I know I'm going a little bit quick. Did you get that case? Ma'am? The court reporter, were you able to, do you have
Yes,
that?
I'm good. Yes,
Okay.
sir. I'm following.
All right, good. All right, counsel, make your appearances.
Your Honor, Lance Kasab on behalf of the plaintiffs.
Paul Stafford on behalf of defendants, Your Honor.
All right, before we go to the scheduling conference, I just want to make kind of a comment real quick. I wouldn't do this if Mr. Stafford wasn't a party in this case. I don't have an issue, and I know people who are attorneys, but I do know Mr. Stafford fairly well. We've served on the Dallas Bar Board of Directors. I don't think there's anything about that would cause me to need to recuse, but I do want to disclose that. Do you have any questions, Mr. Kassam?
No, I mean, I guess if you have not been partners or associated on a case before, then I don't have any problem.
Yeah, we have no business relationship, but I have known Mr. Stafford for a long time.
I understand, Judge.
We served on the Dallas Bar Board. I don't know how many years, but for a few years. Anyway, I just wanted to make sure to disclose. You think about it, Mr. Kasab. I'm not asking you to make any decisions, and if you have any concerns, just please let us know.
Will do.
All right. So we need to get a trial setting on this case, correct?
Yes, Judge.
Your Honor, my appearance is subject to a special appearance, which is set for a hearing at 4 p.m. this afternoon. We had a 91A hearing previous to this scheduling conference. And as the judge knows, a 91A hearing does not waive a special appearance. We have a special appearance hearing later today. So subject to that special appearance, Your Honor, I'm participating in the scheduling conference, but I just wanted to make the court aware of that.
Are you filing a special appearance or a different party?
I'm filing a special appearance on behalf of both of the defendants. It was filed with the response to the petition, Your Honor.
Okay, I guess I haven't looked at this, a special. But you're located in Dallas, right?
I am located in Dallas, Your Honor, yes.
I was just hoping to do a service, I guess. Okay.
Yes, Your Honor.
All right, that's interesting. Okay. All right, let's get this case set for trial then. When do you want to set this for trial?
Probably in the fall.
Stafford, what are your thoughts?
Again, Your Honor, I'm making my comments subject to my special appearance, and so I leave it to the sound discretion of the court. However, I'm happy to provide dates in which I already have a trial setting or conflict if the court has decided that the fall is the time period in which the case will be set.
I have no idea. I don't know about, I know almost nothing about the case, and so I don't know how much discovery needs to be done. from what I've read, it doesn't seem super complicated, but
It's not. My thought is 6 months worth of discovery and maybe a little less, 4 months, and get it set for trial.
you disagree, Mr. Stafford?
Again, I mean no disrespect to the court or to opposing counsel. It's just subject to my special appearance. I'm going to leave it in the discretion of the court on the trial setting.
All right, then I guess we will set it for October 29th. Does anyone have an issue with that?
If I may look at my calendar, Your Honor. Just a moment.
That's a Tuesday?
Yes, we always do Tuesday trials.
Okay.
It doesn't have to be that date. We can pick other dates. It's just the first.
That's fine with me. I do have a trial on a 2-week docket on the 21st. It's a first trial setting. I doubt that it will go. So
I currently do not have a conflict for October 29th. Your Honor.
Okay. Rhonda, go ahead and set it for trial then, and then a mediator for this. What do y'all think? Ken Rubenstein, Jim Jordan, King Pfeiffer, Chris Noland. I don't know. What do y'all think?
whoever you suggest is fine with me, Judge.
We'll leave it in the discretion of the court, Your Honor.
Go ahead and appoint Ken Rubenstein, Rhonda.
Yeah, Judge.
All right, we'll see you guys this afternoon.
Thank you, Judge.
Thank you, Your Honor. May we be excused?
You may.
Thank you.
Are both sides here on Aldridge versus Jones?
Aldridge, yes.
Tiambe Jones for Mona Jones, yes.
All right, let's go on the record on DC 236540 Aldridge versus Jones. Counsel, make your appearances.
I'm Tiambe Jones. I'm the attorney for Mona Jones.
Is there someone on the other? I thought I heard Mr. Aldridge say he was here.
Yes, this is me, pro se plaintiff.
And you need to state your name for the record, please, sir.
Lamont Aldridge, pro se plaintiff.
Okay, let's get started.
Your Honor, on November the 13th, the defendant filed a counterclaim for malicious prosecution and for actual and exemplary damages. None of the they meet none of the elements of malicious prosecution. The first thing I will say is that there was no suffering or special injury by the defendant by me filing this case. They haven't alleged that there's any special injury. The only thing they're alleging are attorney fees. Other elements are they must prove that the proceeding was terminated in their behalf, and that
Judge,
has.
may I interrupt? This is a Rule 91A motion, and the issue is not whether or not we can prove certain things or whether or not Mr. Aldridge agrees with the sufficiency of our proof or even our allegations. The only questions are whether or not the allegations that we've made, if we can prove them, if they would entitle my client to relief. And so these questions about whether or not we can prove them are not really relevant to this motion here today.
Yeah, I do kind of agree with her on that. It just sounds more like a summary judgment from what I've read. Do you want to withdraw your motion to dismiss?
Yes, I would do that.
All right.
Judge, I would ask for our attorney's fees for being here today.
Denied. I will say, Ms. Jones, that I have been on the bench for a long time, as you know. I have seen it is extremely, extremely rare that somebody has given the state of the law in this type of case, a malicious prosecution claim is extremely difficult. And so I want you to really think about, is this something you want to pursue? I'm not saying you can't, but I haven't seen it be very successful in the past. But for now, that's what we're doing. So, and you guys are set for trial. It's a pretty new case, so I don't mind resetting it if you need to, but it's set for trial currently on April 9th.
Oh,
Yes, we would need to push that out.
yes, Your Honor.
Do y'all both agree?
Yes,
Yes, Your Honor.
When would you like to reset it to? You want to shoot for sometime in July, maybe?
that sounds good to me.
I will be in Belize for part of July.
Do you want to do June?
June would be lovely.
Does that work for you, Mr. Aldridge?
Yes.
Does June work okay? Or both? Can you guys hear me? Does
Yes,
June
Your
work
Honor.
okay?
With the caveat that the first week of June is the annual family law convention. So that's the only time in June that I'm not available.
Y'all want to do June 26th, maybe, or 25th?
I'm available either of those 2 days.
I'm sorry, it's just the 25th. I just misspoke. It's the 25th.
25th is fine with me.
Rhonda, are you there? Can you reset this to the 25th?
Yes, Judge. I will set to the 25th.
All right. Anything else today? And Mr. Aldridge, you need to prepare an order denying the request for attorney's fees on this case.
Okay,
All right. Anything else, guys?
Thank you, Your Honor.
Thank
Thank
you. You have a great rest of your day.
You too.
you too.
Okay, our next case is Luna versus Martinez. Are both sides here on that case?
Maddie Doty for the plaintiff, Your Honor.
And Jonathan Bogus for the defendant, Your Honor.
All right, let's go on the record on DC 232396. Luna versus Martinez. Counsel, make your appearances.
Maddie Doty for the plaintiff, Mr. Luna.
Jonathan Bogus for the defendant, Mr. Martinez.
All right, what's going on with this one?
Your Honor, we're here on a motion to reinstate. This case was dismissed for want of prosecution October 24th, 2023. An answer was filed September 13th, 2023. Unfortunately, due to a mistake by my staff, the dismissal was not on my calendar. So I missed that hearing and it was dismissed, and we are asking for it to be reinstated on the active docket. It was a mistake. There was no intention there. It was not a conscious decision to miss that, and we do apologize, but we are requesting it be reinstated so that we can continue. We're in the middle of discovery when it was dismissed.
Any objection to that?
No, Your Honor.
All right, we will go ahead and reset, or go ahead and reinstate that. Let's set this for trial too. When do you guys want to set it for trial?
Whatever you'd like, Your Honor.
Well, how much discovery do you still need? Give me some guidelines.
I think all we have so far is initial disclosures. So I think, it's just a car wreck case, maybe 6 months, 6 to 8 months, a fall.
I can agree with that.
Okay.
All right, and do you have a mediator on this one?
I don't think we do yet. I like a few different people, but if you want to pick as well, Judge.
No, I want to go with who you guys like. There's a lot of great car wreck mediators out there. So first of all, let's pick an exact date for trial. How about October 29th? Does that work?
Let me just double check, but I'm sure I can make it work.
And it doesn't have to be that date. That's just a possible date. Or November 12th or November 19th. November 12th. Let's not do the 19th.
November from 19th, I have nothing set. The other two, I have one set on each day. So November 19th, I could go for sure. The other
No,
two would be a
Let's
coin
not
toss.
do the 19th. I'm trying not to set
Oh.
three trials that week. So
Okay,
let's do the 12th.
Okay.
Or we could do December 3rd, 10th, or 17th.
Your
any
Honor,
of the three will work for me in December.
we can agree. Any of the time in December works.
Rhonda, go ahead and set up a trial on December 3rd. And you were going to say which mediators you like?
I like Lexa. I like Gary Berman, Karen Gammon. This is a Dallas case. So yeah, those three I think are good. Lacrone.
You have a preference among those, Mr. Bogus?
We can agree to, Lexa or Berman, doesn't matter.
I don't have a strong opinion.
Lexa's good.
Do any of you, Lexa I know is a little bit, Lexa Ald a little bit cheaper, isn't she?
She is.
Yes.
And more flexible.
Absolutely.
Let's do Lexa Ald then, if that's who you want. I'm totally flexible. So let's go ahead and appoint Lexa Ald on this one, Rhonda.
Got it, Judge.
And I've signed the reinstatement, sent it to the clerk's office, just so you know.
Thank
Okay.
you so much.
All right. Anything else, guys?
Oh, Your Honor.
No, Your Honor.
And Ron, did you get the trial setting date?
Yes, December 3rd.
Okay. You guys have a great rest of your day, okay?
Thank you. You too.
You too. Thank you.
All right. Anyone here on Thomas v. Mena? Thomas v. Mena, anyone here on that? Let's see, do we have Mr. Vecchio, are you still there?
Yes, Your Honor, I'm here.
Did you ever get worked out what you needed to work out?
I have the defense attorney. She is logged into the meeting or to
Okay.
the hearing.
Let me go back. This was from the DWAP docket, correct?
Yes, Your Honor. Sable to Desta.
Let me pull that up real quick.
Judge.
Hi, how are you?
Good.
Let's go to what case is this again on?
Foster versus Soriano. 07438.
I see it. Okay.
Mm-mm.
And this case settled back in November. What's going on with it?
Well, we've been going back and forth trying to get the motion for the ad litem completed. I think we just had it sent over from the defense attorney. Is that correct, Sable?
Yes, I sent it to your email.
Okay. I don't see it yet, but
Oh,
Okay, so
looks like a motion here, so we can probably get it agreed and filed today. So
okay, so Rhonda, do you see this case?
No, I don't. I'm looking for it now. You said Foster, and what was the other name? Oh, I see it. Serrano.
sorry.
Okay.
Yeah. So let's reset this 60 days. And is it how much was the settlement for the minor?
It was $5,000.
All right. We'll use someone pretty quick, who's fairly inexpensive. So we'll go ahead and appoint, let me just make sure she's around. But have you all used Fabiola Segovia?
I'm
I
not.
haven't, but
but
sounds good.
She's usually pretty quick. Let me just make sure she does travel a good bit. So let me call her right now.
Hello.
Ms. Segovia, this is Judge Hoffman in the 68th District Court.
Hi, Judge. Good morning.
Good morning. We have a case that needs kind of a quick prove up. I was
Okay.
wondering if you're in town.
Yes.
Okay, can I give you the cost number? Do you have something to write with?
Yes, go ahead.
It's and the clients speak English in this, correct?
Yes, Your Honor.
All right.
My
So
client.
DC 227438.
Okay.
And the plaintiff's attorney, who should she contact to get all the information she needs to prove this up?
Abraham Blumensteel.
Did you hear that, Ms. Segovia?
No, I did not. Something steel.
Can you spell, it's Abraham and then last name, spell the last name?
Blumenstiel. Blumensteel.
Did you get that?
Okay, I think so. If you'll give me an office number, I'll get in contact with. Get this.
972-380-4444.
All right.
And the order has not been signed yet. You're going to get that to me today, right?
We will give it our best shot.
So
Can I
go
get-
ahead.
Can I get Miss Segovia's telephone number?
Yeah. Ms. Segovia, you want to give it to him?
Yes, 214-354-2619.
Excellent. Thank you.
And then do you need the defense attorney's phone number? I don't think you do, but.
I don't think so. I'll just grab the emails from the service list and put everybody in one email together.
Okay,
And
thank you.
we have not signed an official order yet. They're in the process of signing that, and there's a 60-day DWAP on this. So you're on kind of a short time frame.
Yeah, that's no problem.
And it's a very small settlement, $5,000.
Okay. All right.
All right, thank you, Ms. Segovia. You have a great rest of your day, okay? All right.
Thank you.
Bye-bye. Okay, anything else, guys?
Oh, no, that's all. Thank you.
Thank you. You have a great rest of your day.
You too. Bye.
Thank you, Judge.
And Rhonda, you got resetting that case 60 days?
Yes, thank you, Judge.
All right, I think we were trying to get announcements on the continuance motion for 1015. Was there anyone here on that case, Mr. Zaidi or Mr. Ewing? Maybe the case is settled. This case should be taken off the Rhonda, this Thomas v. Mena, they settled that case and sent it a dismissal. I'm going to go ahead and send that to the clerk's office.
Okay, so that just closed it. Okay. I won't set it on the DWAP.
It doesn't need to be on the DWAP. They've sent in a dismissal order. I'm going to sign that right now and get that to the clerk. Okay, we've had a busy morning so far, guys. Is anyone else here still from the dismissal docket that I've missed? All right, Ron, I've sent that in. Okay, our next hearing is okay. All right, is there anyone else? Actually, let me see, is there anyone else here? Mr. Bonneau, what are you here for?
Your Honor, and I'm about 10 or 15 minutes early. I apologize, but I have a one issue or two issue motion to compel that's set for 10:45.
Perfect. So yeah, I think we're going to take a quick break and give the court reporter a chance to relax, and we'll reconvene at 10:45.